Order. Neil Hanvey to move the motion.
Thank you, Mr Dowd. I beg to move that this House has considered UK military action in Iraq and declassified documents from 1998. By way of introduction, I'd like to pay tribute to Declassified UK, and in particular their co-founder and editor, the journalist and author Mark Curtis, who has provided an invaluable public service, shining a light on declassified British documents at the National Archive from 1998. These documents, which run to over 900 pages, reveal what actually went on behind the scenes in terms of the UK government's decision to take military action in December 1998 in what became known as Operation Desert Fox, the four-day bombing campaign in Iraq from the 16th to the 19th of December 1998 by the United States and British militaries. This is important in and of itself, but also because, as we know, it was the precursor to the invasion of Iraq in 2003. Before I turn to the key findings contained in the declassified documents, at the outset I will recap on the human cost of military action in Iraq. This House will forever remember the sacrifice of the 179 British servicemen and women, as well as the 23 British civilians who lost their lives during conflict in Iraq. Yesterday, I joined the Scottish War Widows for their Christmas gathering, and I want to pay tribute to my Kirkcaldy and Cowdenbeath constituent and their secretary, Sue Raw, and the amazing women and men who lost a loved one during or as a result of the lasting consequences of conflict. In addition to this, there is also the horrific human cost of the war in Iraq. A research study published in The Lancet in 2006 estimated that over 655,000 Iraqis had died as a consequence of recent wars. In November 2006, the United Nations High Commissioner for Refugees reported that 1.8 million Iraqis had been displaced to neighbouring countries and 1.6 million Iraqis were displaced internally. As recently as March 2023, the Watson Institute at Brown's University estimated that 1.1 million Iraqis were still displaced internally or live as refugees abroad. According to an April 2014 Guardian report, the war cost the British taxpayer £9.6 billion. Doubts over the legality of the invasion of Iraq have done irreparable reputational damage to the Western world, including the United Kingdom, throughout the Middle East and among Muslim populations both at home and abroad. I will now turn to the key findings from the declassified documents in relation to discussions involving and advice given by the then Foreign Office Legal Advisor, the Solicitor General, the Chief of the Defence Staff, the Attorney General and the Deputy Secretary for Defence and Overseas Affairs. On the 12th of February 1998, the Foreign Office's legal advisor, Sir Franklin Bremen, wrote to his department's senior civil servant, and I quote, said, "The only valid claim to employ force in this case is under the authority of the Security Council. My view is that a new resolution is resolution in suitable terms is sine qua non." He added, "The Ministerial Code requires ministers to comply with the law, including international law. I cannot believe that ministers would wish to order British servicemen into action unless their legal advisors were able to assure them that it was legally justifiable." The then Prime Minister Tony Blair was again told of the Foreign Office view 2 days later, on the 14th of February, in a meeting with the then Solicitor General for England and Wales, the now Lord Faulkner. Referring to the UK's invasion of Egypt over Suez, Lord Faulkner told Tony Blair that in the Foreign Office, and I quote, "Some lawyers argued very strongly that it would be the first time since 1956 that the UK had used force without the backing of a Security Council resolution. Some lawyers might feel strongly enough to resign." Lord Faulkner stated this since they might be expected to implement decisions, as he said, that they believed were incompatible with international law. 5 days later, on the 19th of February, the Prime Minister, Tony Blair, the Foreign Secretary, Robin Cook, and the Defence Secretary, now Lord Robertson, attended a briefing by Chief of the Defence Staff, Sir Charles Guthrie, and Air Marshal John Day on, and I quote, targeting plans for operations against Iraq. The minutes note that the Chief of the Defence Staff mentioned that he was worried about the legal side. He hoped this could be sorted quickly. The minutes then state the Prime Minister, Tony Blair, noted that the legal advice was that securing another Security Council resolution was preferable. It added, the Prime Minister concluded that he did not want to have anything depending on securing a further resolution. What on earth did he mean by anything? What exactly had he committed to? We know that Tony Blair had been told by then in a communication entitled The Legal Use of Force from Michael Pakenham, Deputy Director for Defence and Overseas Affairs, to John Holmes, the Principal Private Secretary to the Prime Minister, that a further resolution was essential, not preferable. Tony Blair's statement in the minutes of the meeting with the Chief of the Defence Staff implies that he would be prepared to use military force without such a resolution. That is unlawful, yet that is exactly what happened as events transpired. One note in the bundle of papers, which is undated but likely to be from February 1998, appears to be from officials in advance of a meeting between Tony Blair and Attorney General John Morris. This note suggests that Tony Blair pressed Morris to legally justify the use of force. The speaking notes for the Prime Minister's Iraq, the legal position, references Morris's memo of the 14th of November 1997, and that it helpfully indicated there could be exceptional circumstances in which the use of force could be justified without a Security Council statement. It then says, I trust that you can confirm now that my description of what would constitute exceptional circumstances is correct. However, Morris's memo clearly states the following. Such a situation has not yet arisen, and even in such extreme circumstances, the UK could expect to be questioned closely about the legal basis for its resort to military force. The government would need to have the strongest factual grounds for such an action. This advice from Attorney General John Morris makes it clear that a Security Council statement was an essential precondition to using force. In July 1998, Michael Pakenham, the Deputy Secretary for Defence and Overseas Affairs, wrote a confidential note entitled The Legal Use of Force. This was sent to John Holmes, the Principal Private Secretary of the Prime Minister. He said the Foreign Office legal team was continuing to advise the following. The bottom line remains that in most foreseeable circumstances, a resolution of the UN Security Council is required before the use of such force can be authorised. He added that, acting against UN principles or without UN Security Council resolutions may in the short term meet immediate need, but is in the long term wholly contrary to our interests. The communication also states the advice given by the FCO legal team and closely followed by the law officers is that there are certain fundamental rules which any government must follow and tests they must meet before authorising the use of force by our armed services. Without such tests being met, there would be a very real risk of members of the armed services being subject to criminal prosecution. So, in summary, the then Foreign Office legal adviser stated that the only valid claim to employ force was under the authority of the United Nations Security Council. The Solicitor General warned Tony Blair that there were lawyers who might resign rather than have to implement decisions incompatible with international law. And what is absolutely clear is that neither the Foreign Office's legal adviser nor the Solicitor General were willing to advise that military action was legally justifiable. And we have evidence from the then UK Prime Minister, pressing the then Attorney General to provide a legal justification for military action. If that wasn't concerning enough, we also had the Chief of the Defence Staff stating he was worried about the legal side. Crucially, the Deputy Director for Defence and Overseas Affairs offered absolute clarity that the bottom line remains that a UN Security Council resolution is required before the use of force can be authorised. In fact, the communication sent to Downing Street makes clear that the Prime Minister's office was told that this was essential. On the 14th of November 1998, Tony Blair authorised the strike on Iraq, but UK and US forces were stood down at the last minute when Saddam Hussein agreed to permit weapons inspections. Just before Iraq's climb down, Tony Blair held a meeting with the Foreign Secretary, Robin Cook, Defence Secretary, now Lord Robertson, and the Chief of Defence Staff, Charles Guthrie, in which he affirmed, and I quote, "The time had now come for military action to be taken against Iraq." According to the ministers of that meeting, there was no consideration of legality, except that it was agreed to justify the use of force not because he, Saddam, was in technical breach of UN resolutions, but because he posed a real and imminent threat to peace and security in the region. As Declassified UK have stated, and I quote, "This was a de facto acknowledgement that the threshold demanded by Britain's legal advisers and new Security Council authorisation had not been met." On the 16th of December 1998, the US and UK struck Iraq in a wave of air attacks. Almost 100 sites were attacked by US and British aircraft with cruise missiles from US Navy ships and B-52 bombers. General Peter de Ballière, a former head of the SAS who commanded British forces in the 1991 Gulf War, questioned the political impact of the bombing campaign. It is clear from these declassified documents that Tony Blair misled Parliament. When he announced military action to Parliament on the 17th of November 1998, he said, and I quote, "I have no doubt that we have the proper legal authority as it is contained in successive Security Council resolution documents." But this was clearly misleading, as he had been consistently advised by the Solicitor General, by the Attorney General, by the Foreign Office Legal Advisor and by the Deputy Secretary of the Defence and Overseas Affairs that further UN authorisation was required for the use of force. Thus, British officials justified their action by claiming that other UN resolutions previously passed in 1998 revived the authorisation to use force provided in Resolution 678, a remnant of the Gulf War passed 8 years earlier in 1990. But since these other resolutions did not explicitly authorise the use of force, the UK argument is a spurious one. Of the 15-member Security Council 1998, only 3 members supported the action. That was US, Japan and Portugal. And 5 years later, in 2003, the UK and US relied on the same Resolution 678 to justify their subsequent invasion when they again failed to secure a further Security Council resolution for the use of force. These files from 1998 suggest Tony Blair was motivated more by maintaining relations with the US than by upholding international law, as he was again culpable of in 2003. On the same day, President Clinton told Tony Blair during a phone call that military action against Iraq might have to be used. Blair replied saying he agreed and that Mr. Clinton could, and I quote, "could count on our support throughout." That commitment of support was not underpinned by international law. On the point of Saddam Hussein being unwilling to cooperate, Tony Blair said, "We would have to enforce our will." Blair said, adding, "even if there were some differences between us on the legal front." According to Declassified UK, Blair was intimating to the US President he was prepared to override British legal concerns and obligations. On the 14th of February 1998, as Washington and London were close to striking Iraq, Blair told Solicitor General Lord Faulkner, I quote, It was inconceivable that we would refuse the Americans the use of the base at Diego Garcia. At the very least, this had to be legally possible. So far, the government has not declassified all files relating to this period. It has kept secret several of the Iraq files from the Prime Minister's office covering the end of 1998 and the beginning of 1999. Can the Minister explain why these documents have not been put in the public domain and when we can expect publication? The files do not appear to contain the minutes of the meeting between the Prime Minister, Tony Blair, and the Attorney General, John Morris. So can the Solicitor General confirm if this is the case and if the minutes will be published in full and when? These declassified documents show Tony Blair was determined to take military action against Saddam Hussein in 1998 against explicit advice and in the absence of sound legal arguments or justification. These documents show Tony Blair dismissed legal objections to his 1998 bombing campaign. This was the direct precursor to his stance over the invasion of Iraq 5 years later in 2003, which also was deemed illegal by UN Secretary-General Kofi Annan when he said in September 2004, from our point of view and the UN Charter point of view, the war, was illegal. Indeed, it was the former Foreign Secretary, Jack Straw, who privately warned Tony Blair in 2002 that an invasion of Iraq was legally dubious, stating, and I quote, "Regime change per se is no justification for military action, and the weight of legal advice here is that a fresh UN mandate may well be required." These words chime with and are foretold in the declassified documents which I've highlighted today. I want to place on record my appreciation to parliamentarians who have raised similar concerns to mine today in the past. These include the former Labour MP Dennis Canavan, the Right Honourable Member for North Islington, and the SNP's Margaret Ewing and Jim Sillars. I recall that Margaret Ewing questioned the Prime Minister directly in the House of Commons at the time, and Jim Sillars in 2016 called for a retrospective Iraq War Crimes Act to be passed by the Scottish Parliament. It was the Right Honourable Member for Halton Price and Howden who stated, "The second Iraq War was started to liberate the Iraqi people. Instead, it shattered their country. It was intended to stabilise the Middle East. Instead, it destabilised the Middle East." He deserves credit, as does my own party leader, the Right Honourable Alex Salmond. Mr Salmond was right when he said, and I quote, "Through the long debates on Iraq, many of us suspected that the Prime Minister had given commitments to the American President which were unrevealed to this House and to the public. The Chilcot report outlined these in spades. The famous phrase, 'I will be with you whatever,' will go down in infamy in terms of giving a commitment. In both instances, in 1998 and in 2003, we know Tony Blair received legal advice warning that military action was illegal. And in both instances, he ignored that legal advice and went on to authorise the deployment of British service personnel. Blair pressed officials, in particular the Attorney General, to provide legal justification for the use of force. He received none, but he did it anyway. Blair misled Parliament by claiming that a legal basis for military force without a UN Security Council resolution existed, when in fact it did not. The consequences have been devastating for Iraqis, for the region, and for military personnel and their families. Lives lost in the theatre of war are well understood, but the lives wrecked by the trauma of conflict are less easily quantified, and yet every bit as real. I heard such stories yesterday when speaking to the war widows. Such loss and devastation is met with great courage by those affected, but every person's loss should surely be based on a lawful instruction. How can it be that a Prime Minister who prosecuted 2 wars against lawful advice and instruction has been rewarded with a knighthood? This is an insult to every single life lost, and it should be withdrawn forthwith and a path to full justice secured. Governments should not lie to go to war, and the truth must now be told. I so move.
Thank you. The question is that this House has considered the matter of UK military action in Iraq and declassified documents from 1998. I intend to take the opposition spokesperson no later than 17:40, so just bear that in mind, please, during the interventions. Can I ask Jim Shannon, please?
Thank you, Mr. Chairman. Can I first of all thank the honourable gentleman for Kirkcaldy and Hanvey for setting the scene so very well. I also thank him, and I spoke to him beforehand, for his focus quite clearly on the truth of the matter, first of all, but secondly, on the sacrifice of those who gave their lives, and some of those, I understand, are in the gallery today, their families. So I want to convey, first of all, my sincere sympathies, thoughts to those who lost loved ones and who live with the pain of that loss today. And the Honourable Gentleman for Kirkcaldy and Hanvey, I think, said that incredibly well in his contribution, and I want to thank him for that. I know others will focus upon that as well. As we're all aware, very well aware, in April 2023, Declassified UK, a media organisation which focuses on the work of the British military and intelligence agencies, published an article about declassified documents which are now declassified, and said, indeed suggests, that the Prime Minister, Tony Blair, was informed military action was unlawful without UN authorisation, but proceeded with Operation Desert Fox in Iraq in 1998 nonetheless. I can well remember at that time, Mr. Chairman, that we had been dealing with the fallout of the Troubles, and the thought of war was not something that I relished, and yet I am also mindful that evil triumphs where good men do nothing. I do declare an interest as a former soldier, Mr. Chairman, for the record. I served in the Ulster Defence Regiment and also served in the Royal Artillery for some 14.5 years. I enjoyed the service, but I think I need to put it on record as I speak about these things. I've not had a chance to read the reports themselves in their entirety, but I've read a number of articles on this issue, and it is clear that things were withheld from the public. Again, in Northern Ireland, there is a circumstance which we are all too familiar with, and the taste left in your mouth when you see the difference between your lived memory of a timeline that I lived through, and others as well, of events and the facts behind the scene. It is not a good taste. The declassified British documents at the National Archives appear to show that Blair was already set on taking military action against Saddam Hussein's regime throughout 1998 in the absence of legal arguments to justify it. I find it difficult to grasp that, Mr. Chairman, yet I also know that sometimes open information is not the same as intelligence passed on, and I'm loath to comment too deeply into the matter, as I am also aware, very aware, that documentation does not accurately cover what I lived in Northern Ireland either. However, one thing I do wish to clearly state, that opinions on whether Blair's government took the right steps in 1998 on the right information do not alter the irrefutable fact that our armed forces acted with dignity, and our pride in them and their actions must be clear. We cannot allow those who have sought to undermine our armed forces for so many years to grasp these documents as part of their war on the honour and integrity of our armed forces personnel. Forgive me, Mr. Chairman, I admitted to welcome the Minister to his place. I know he's just been in post the last probably week or thereabouts, or even less perhaps, and I want to wish him well. He's been a good friend of mine, a good friend of us all, by the way, over the years, and I very, very much look forward to what he's got to say, and also look forward to the Shadow's contributions, because he's a man that I've known for a long time and value his contributions. To go back to the subject matter, the presence of our military, of our armed forces, was called for by their government. Their conduct was regimented and measured, and their names must retain our sincere thanks and appreciation. And I believe that this must be clear in this debate, regardless of the opinion of Blair's decisions and the documentation. anyone feels should or any way calls that into question, or indeed the intelligence that we now know underlines the need for the war. The presence of the armed forces is not something that can ever be questioned, ever be in doubt. And I know that the honourable members all agree with me when I say that. The deaths of those men, young men and women, were not in vain, and the actions they took, the position that this government put them in, that lives with them to this very day, were right and proper. And we remain proud of their contributions and their actions. And history, I believe, Mr. Chairman, must never forget and reminds us all of their contribution, of their service, and indeed of their sacrifice. Again, I commend the honourable gentleman for Kirkcaldy and Cowdenbeath for bringing this forward, and to those in the gallery who have lost loved ones, my sincere commiserations. Thank you.
Thank you. Richard Ford.
Thank you, Mr. Howden. It's an honour to serve under your chairship. And I'd like to first start by paying tribute to the honourable member for Kirkcaldy and Cowdenbeath for calling this debate, because we don't often have debates on things that are historic. It's very normal for Parliament to be focused very much on the present day and on things that are very current. And I think it is so helpful to us sometimes to look back in history and learn lessons from our recent past. So I think it's excellent that he's pulled back into the National Archive to extract this information that he and others have been reporting on. I'd also like to congratulate the new Solicitor General in his new post. I met with the Honourable Member for Witney and West Oxfordshire shortly before he became Chair of the Defence Committee, and I know that he would have done an excellent job in that role, but that his services are obviously required by government instead. And I would like today to draw specifically on some of the things that the Honourable Member has talked about in relation to Operation Desert Fox from 1998. Also to make some reference to the invasion of Iraq by the US, UK and others in 2003. And then finally, just to perhaps ask one or two questions about the role of Parliament in the declaration of war, that is, in the commitment of UK armed forces in going to war. So we've heard already a great deal about how the Prime Minister in 1998 was operating with knowledge of what was legal and decided perhaps to park that, or in large part put that aside and decide to press on with Operation Desert Fox nonetheless. And hence we saw the 4 days of bombing of Iraq. I think also what's fascinating alongside international law is to hear from the reporting of that time, from this newly released material, what was being said to the Prime Minister at the time from a pragmatic perspective. It wasn't just legal advice that he was receiving. He was also receiving advice around the UK's interests. So, for example, the chair of the Joint Intelligence Committee at the time, Sir Michael Packman, was saying to him that to engage in military action would be to act against UN principles, and that would be in the long term wholly contrary to our interests. But given that the material that's come out of the archive is largely about legal advice, I would say it's fascinating to read that Robin Cook, the Foreign Secretary of the day, and other legal advisers were suggesting that there would have been a serious problem unless the UK were to act with further UN Security Council resolution mandates, and that we might be seeking instead to get a new Security Council resolution that would state that Iraq was in material breach of previous UN Security Council resolutions. I was also very interested to hear from the Honourable Member those fascinating insights of how the Chief of the Defence Staff at that time was saying to the Prime Minister that we really did need legal support for military action if it was to go ahead. And that doesn't surprise me of Sir Charles Guthrie, because he was an excellent CDS. I had the privilege of having a conversation with him at a bar while he was still serving. And he had recently, prior to that, written a book on the just war tradition, Ethics in Modern Warfare. This dealt partly with jus in bello, that is, the just war theory as it applies to the conduct of war, and we've been talking about that a lot in the House in recent weeks in relation to Israel-Gaza. But he also wrote about jus ad bellum, that is, how wars are initiated. And I mean, he was clearly somebody who knew a lot about international law. Now, I'd like, lastly, to talk a little bit about what light these revelations cast on the relationship between this place, Parliament, and also the executive and the judiciary. I mean, it was customary until 2003 for wars to be, I should say, for armed force to be committed, for our forces to be committed by royal prerogative, and indeed, you know, it is the sovereign decision of the executive to commit our armed forces to war. 18th of March 2003 changed something there, because in March 2003 a debate was had in Parliament, as it happened before, but on that day there was also a vote on the invasion of Iraq. And people will recall that on that day that there was a very, very large majority of vote in favour by MPs of the day in favour of UK joining military action in Iraq. Now, in opening, Tony Blair offered the following: "It is right that the House debate this issue and pass judgment." Clearly, he said those words knowing full well that he had the support of many on his own benches and on the Conservative benches. I should add, as a footnote, Tony Blair referred that day to the Liberal Democrats as unified in opportunism and error. And he said that because, as a party, we were indeed unified in opposition to the invasion of Iraq. The point is that this was a case of Parliament getting an opportunity to have its say on the commitment of UK armed forces to war in Iraq. And I raise that because I think what the documents that we are discussing today reveal is that the executive was going beyond legal advice, was going beyond even the advice of really expert opinion, such as the chair of JIC and the CDS, and was making an executive decision that essentially came down to the view of the Prime Minister. And I think it's troubling that so much authority was ultimately vested in that individual. And I think what we can take from that period is that in future, the legislature ought to have greater scrutiny of decisions to commit our armed forces to war. And so, just finally, I suppose I'd be interested in when the Minister stands to his feet in any reflections he has on how UK armed forces will be committed to war in the future. Thank you.
Thank you. Kenny McCaskill.
Thank you, Mr Dowd. A pleasure to serve under your chairmanship, and like others, I pay tribute to my party leader and colleague for a very forensic examination, and I pay tribute to Declassified UK for the information that they have provided. It is appropriate that we should be debating this because it's something that we must never, ever forget. It's ironic that actually today I noticed in social media that this is the anniversary of Saddam Hussein being discovered in his hiding and the dishevelled despot being brought out. I have to say I have a moral objection to the death penalty, but I think, like everybody else, I shed no tears for Saddam Hussein. He was a deeply evil man, although I do think it would have been better had he been brought to trial at the International Criminal Court in terms of normal rules than simply hung. Because the consequences of the Iraq war, as was said by the member for Kirkcaldy and Cowdenbeath, live with us and reverberate with us to this day. We were taken into war on a false prospectus. We were taken in on deceit and indeed on lies, and it's important that that should be brought to account, because the world is a far less safe place from that war that has been come about. Millions have died, not simply in that country, but around the world. A refugee crisis that we now see and live with was kicked off and has continued. And perhaps also more worryingly, the moral authority of the Western democracies has been lost, and you can trace it back to the war in Iraq. That is something that I'll go on to comment about. I have some sympathy for the Minister because he is having to deal with the sins of a different administration. But as has been mentioned by others, the Tories were joined at the hip with Labour in this war and have to take account for the consequences, even if the principal villain was Tony Blair. There were those, and people's names have been mentioned. And indeed, there are two in particular who I think we should thank for their actions. Robin Cook has been mentioned, was deeply principled. I knew Robin Cook. I stood against him. I disagreed with his position in the constitutional status of Scotland. But nobody should forget the courage, not just the courage he had, but the convictions that he retained. And in speaking out against the Iraq war, we should never forget him. And it's a tragedy that he's not here with us today. Equally, Charles Kennedy spoke out against the Iraq war. He was indeed decried for it, but it was principled. I recall marching with Charles Kennedy in Glasgow when over 100,000 people in Scotland marched, as indeed they marched in London and in other cities, not simply across the UK, but across the world, to say, this is not in our name. But Tony Blair took us to war despite the objection of principled people like Cook and Kennedy, and despite the millions marching across the United Kingdom, and we live with those consequences today. But where is the accountability? Yes, we've had Chilcot. Yes, we've had some matters put out there, but nobody has been held to account. We were told it was weapons of mass destruction. We were told we were only minutes away from doom and gloom, and indeed the death of democracy, the death of humanity almost, it was portrayed, and that was shown to be a lie. It was the same lie that was perpetrated about going into Afghanistan, the United States, when they said it was all about 9/11, when it was quite clear if they were going to deal with the perpetrators of 9/11, it was Saudi Arabia that you should be addressing. But as with Khashoggi, people turned a blind eye to an ally, or indeed one, as with the United Kingdom, one that you view as a bankrolling your armaments industry. So, as I say, it was formed on a strategic lie. It was done for oil, access to oil, and indeed for wider geopolitical positions. But the problem is that we have to live with it today, and the consequences do reverberate, and in particular, that brings back, as is often mentioned in political debates, the quote by Santayana, that those who do not learn from history are condemned to repeat it, because repeating it we have been, and repeating it we are. We have seen the disaster that has befallen Ukraine, but we worry why and wonder why 85% of the globe hasn't signed up for sanctions against Russia, and I believe there should be sanctions against Russia. I condemn Putin for the invasion, even if I think that some actions have been taken have been wrong, and I don't support the actions of the United States. But let's remember that at the end of the day, the rest of the world is not seeing this the same eyes as we are, because they're saying, where's your moral authority when you were prepared to go into Iraq and you now condemn Putin? We are paying the price for Blair's folly. Equally, I have to say, I also remember the criticism, rightly so, of Wagner. But what was the precursor of Wagner? The precursor of Wagner was BlackRock. Yep. Because let's remember, after Iraq, we privatised war. We saw war privatised, and we saw basically private militias that made a lot of money for individuals come in and take over something that had previously been dealt with by a military representing the state. So before Wagner came on the scene, it was BlackRock, and that affected us. It wasn't just a corporation in the United States. I met young Scottish soldiers who told me about colleagues of theirs who were actually deliberately failing drug tests because it was actually better to go and be paid 100,000, as you were getting, to go and be militia or contractors. And let's remember, when we talk about contractors in places like Iraq, they weren't bricklayers, they weren't scaffolders, they were soldiers carrying out private work for what America and indeed the UK carried out. That was the precursor, as I say, that started with what Blair did, and we reverberate and it lived with us, and we have to face those consequences. Now, of course, we have Gaza, and we see the Western democracies again failing to speak out. We see the UK abstain, and we see the United States object, and you wonder why countries such as South Africa, such as Brazil, are looking at the Western world and saying, who are you to lecture us? Who are you to go on about Putin? Who are you to go on about the sins of Saddam Hussein when you are prepared to turn a blind eye to what you do in funding and supporting the Israeli Defence Forces? All of that comes back, and that's why there has to be honesty. That's why there has to be accountability, because Iraq has fundamentally damaged not just the United Kingdom, it has damaged Western democracy. We were lied to as a people. The objections of the people that were vociferous, where people marched in the hundreds of thousands, were literally ignored by executive diktat. That mustn't be allowed to be repeated, and that's why we need to get these documents out there. And those who perpetrated this sin, and it was a mortal sin, must be and should be held to account.
Thank you. Carl Turner.
Thank you very much indeed. It's a pleasure, as always, Mr Dowd, to serve under your chairship. It's also a great pleasure to welcome to his place the new Solicitor General, the Honourable and Learned Member for Witney and West Oxfordshire. We're both relatively new to our roles, although I've a benefit, Mr Dowd, of, I think this is my second tour in this particular circuit. I'm sure, just like today, the tone of our debates will remain as thoughtful and constructive as that maintained by our previous occupants of our roles, and I look forward to those debates over the weeks and months ahead. Let me commend the member for Kirkcaldy and Cowdenbeath on his determination in securing this debate. I know he's had previous attempts at securing urgent questions on this important issue, and no one can doubt the sincerity of the concerns which have led the honourable gentleman to pursue this matter and raise this debate today. And whether or not we reach the same conclusions about it, I applaud and commend him for his persistence in raising this issue. The member for Kirkcaldy and Cowdenbeath argues in a powerful way that there is a through line between the discussions that took place within Tony Blair's government in 1998 over the decision to carry out airstrikes against military assets in Iraq without authorisation from the United Nations, and the decision 5 years later to take military action against Saddam Hussein. The contention is that the decision in 1998 paved the way for the decision in 2003, and that, despite the 12 volumes and more than 2.5 million words of the Chilcot report, we cannot fully understand the process that led to the 2003 decision until the 1998 decision is subject to the same level of scrutiny, including the release of all outstanding papers on the issue. Let me say, I understand the point that the member for Kirkcaldy and Cowdenbeath is making, and as I've said already, I don't doubt the sincerity of the concerns that lie behind his campaign on this matter. It's worth saying, however, that there's another rather more immediate through line from the decision taken in respect of Iraq in 1998, and that was the decision taken by Tony Blair and Bill Clinton just a year later in respect of the intervention in Kosovo. There again, a UN resolution in favour of action could not be achieved because of the permanent Russian veto. There again, as we'll surely discover when the relevant papers are released, there were debates both inside and outside of government about the legality of acting without the cover of a UN resolution. And there again, the judgment ultimately made by Tony Blair, Bill Clinton and other NATO allies was that the airstrikes they authorised against military assets were justified because of the civilian lives that were at threat in those assets were left, if those assets rather were left intact. People, Mr Dowd, may disagree with the airstrikes in Iraq in 1998. They may even disagree with the airstrikes in Kosovo in 1999. But it's important to recognise that what was going on in that era was not some specific obsession with regime change of Saddam Hussein, which would lead to the tragedy of the Iraq War in 2003, but a constant debate about whether the world could afford to wait for action from the United Nations following the tragedies of Rwanda in 1994 and Srebrenica in Bosnia in 1995. So I hear what the member for Kirkcaldy and Cowdenbeath is saying, but while he may maintain the willingness to set aside legal concerns over the 1998 action, was the precursor to what happened in Iraq in 2003, we also have to remember, if that same willingness to act had not been present in 1999, then we'd still be talking today about how the world stood by and allowed genocidal destruction of the Kosovoan people. Well, I won't, if you don't mind, because I do want the Minister to have a full opportunity to respond to the honourable gentleman. The final point, Mr Dowd, I want to make relates specifically to the issue of which documents have been published in relation to the 1998 action, which is still being withheld from publication. I have no knowledge of how those decisions were arrived at, but I'd just urge a bit of caution before we leap to any conclusions or encourage any theories that there are already existing out there about the still unpublished papers may or may not contain. In my experience, when officials, in whichever department it is, sit down and sort through these documents and decide what to publish and what to withhold, they're always rather more concerned with what precedents will be set for the future and whether there are any security implications for individuals still alive in the present, and rather less concerned, in my view, with what revelations will emerge about the past. Personally, I'm in favour of maximum transparency, wherever that is possible. And I'm also in favour of government departments being clear about the broad reasons for the decisions when they feel obliged to hold material back from publication. And if there are any more concrete reasons that can be provided today why the particular papers at issue, in this case, have not so far been published, then I'd welcome that as well. But as I say, not because I think there is any great mystery being covered up, but precisely because I think the opposite is true, and the government could dispel a lot of unnecessary and ill-founded speculation if it was clearer about, as I say, the broad reasons why some material is withheld. If that is one positive outcome that can be emerged from this debate, I'd welcome it. But as I say, another would be to recognise that what motivated much of the action we saw during this period in history was not the desire for regime change in Baghdad, but a compulsion that many leaders rightly felt not to repeat the grave mistakes of Bosnia and Rwanda. Finally, Mr Dowd, I want to offer my sincere commiserations to the loved ones of those military personnel and indeed civilians that lost their lives in these terrible, tragic conflicts.
Minister, thank you.
Thank you, Mr Dowd. It's a great honour and a pleasure to serve under your chairmanship this evening. And may I just take a moment to thank honourable members who've been kind enough to welcome me to my place. I look forward to working with them on this issue and many others, and to serving the House in this new role. My honourable member for Hull East and I know each other well from maritime matters already, and I'm confident that we will have, as ever, the constructive relationship that the House would expect. May I, on this topic, also start by extending my commiserations to all of those who've been affected, families, friends, British personnel and civilians. We deal with enormously sensitive, tragic, historic matters here. And whilst we will talk about some of the detail of disclosure matters and decisions that were taken, we should never lose sight of the fact that at the end of this, the beginning and end of this story, is people whose lives have been irrevocably changed and in some cases ended. And I know that the House will join me in recognising them. Now, the Honourable Member for Kirkcaldy and Cowdenbeath has secured this debate to discuss the declassification of documents arising from UK military action in Iraq in 1998, and indeed the action itself. And he has opened a number of matters before us which are with the merits of that action. I, of course, have to start by saying at the outset that these are historic matters. They have been exhaustively and subject to exhaustive and detailed examination in other places. He will, of course, know that, and I refer him, of course, to those matters. These were matters for many administrations ago, and not one that this government can comment on in the merits. But what I'd like to be able to deal with today is some of the issues around the disclosure of the documents, which are things that I, as the Solicitor General, can comment on. And I hope to be able to offer some constructive comments there, and then invite him to assist me in some other areas. So I'd like to deal with some of the process of the declassification of historic records, also to discuss the convention relating law officer advice, which is relatively understood, but of course departed from in some circumstances, such as the ones he's mentioned. And also just to mention some of the changes that have been made post-Chilcot. Of course, Chilcot's terms of reference did not include the area that he specifically refers to today, but nonetheless, coming afterwards, there were some changes into the way that Parliament and government approaches those matters, and I will address, if I may, some of those today. Now, in relation to UK military action in Iraq in 1998, certain documents, including advice from law officers, have been declassified and released to the National Archives. The Honourable Member, I understood, has shared a link with the Department which covered some documents that he wanted to discuss today. My understanding is that those particular documents have in fact now been declassified and are now open for public review. I think that's the case. I'm grateful for confirming it. The catalogue it goes on an updated process, and I think that's the position with those now. He did, however, mention some specific documents, and he asked me to comment on why they were not available. I apologise in advance. I'm not able to give him the answer to that right now, but if he were to write to me and were to draw my attention to the specific documents that he refers to, I will either be able to give him an answer. I'll be able to give him an answer, and I'll either be able to point to where they are, or if not, I'll be able to give an example, give the explanation for that. But of course, it's for the Cabinet Office rather than the Attorney General's Office to take a view on whether documents should be disclosed and whether in full, and whether they have redactions for any reason or not. So if I can make that request and offer, as it were, at the outset, then I hope to be able to give him some assistance. But may I also, Mr. Dowd, make some just comments on the framework for disclosure? It may be of assistance. The Public Records Act of 1958 places government departments under an obligation to identify public records with historic value and to make arrangements for their permanent preservation. That Act imposed a duty to open these records after the passage of 50 years. That 50-year rule was reduced to 30 years by the Public Record Act of 1967 and 20 by the Constitutional Reform and Governance Act of 2010. Departments may retain records subject to the approval of the Secretary of State for DCMS. And the Freedom of Information Act of 2001 created a duty on departments to justify whether records transferred to the National Archives should remain closed to the public. But the general rule is that the material which is 20 years old becomes those public records. There have been a number of bespoke bodies responsible for the physical housing of this material, but since 2008 it's been the National Archives. And as I've mentioned, there's a framework based on the exemptions for disclosure that's contained in the Freedom of Information Act, and that determines whether material transferred to the National Archives should be open to the public. There are several exemptions which are not time limited. Now, those include national security, defence, international relations or information provided in confidence by other states or international organisations or courts, the economy, criminal investigations, parliamentary privilege, health and safety and environmental information. A number of those exemptions will require the department which owns the information to carry out a balancing exercise as to whether it's in the public interest to disclose that material. That requires consulting across Whitehall and other bodies, and the outcome of that test is subject to the approval of the Secretary of State for Culture, Media and Sport, who's advised by the Advisory Council on National Records and Archives. There's a separate scheme, the Security and Intelligence Instrument, which is approved by the Secretary of State for Culture, Media and Sport, which governs information relating to the security and intelligence agencies. That information is retained in the departments, and information retained by way of this instrument has to be re-reviewed every 10 years. Regardless as to how retentions or closures are made, anyone is able to challenge such closures and retentions by submitting a Freedom of Information request to the National Archives for closed material or to the originating department for retained material. I hope that's been helpful to the House with regards to the procedure for the disclosure of such records and gives an overview of the position. The second point I'd like to spend a minute or two on is the Law Officers Convention, which I know the House will be familiar with, but it's worth rehearsing in a little bit of detail. I think that some of the aspects the Honourable Member has been speaking about does indeed refer to legal advice that is given at the time, or even the advice of the law officers. And some of that material, in this case, as he knows, is available in the National Archives. Now, as a general rule, there are clear and I know well understood reasons for not disclosing legal advice, and there are specific considerations around advice that's given to government by law officers. They may not be relevant to the context and background of this debate, because this is a historic matter and that advice has in any event been published. But simply for completeness, it's usual practice that advice that's given by law officers and the advice that's been sought, or indeed the fact that advice has been sought, isn't disclosed. That's the Law Officers Convention, and that's reflected in the Ministerial Code. So the fact that they have advised, law officers have advised or have not advised, mustn't be disclosed outside government without their authority. It's only in narrow occasions that that has been waived, and that's with the consent of the law officers. And as the Honourable Gentleman knows, perhaps the clearest example of this was the legal basis for the invasion of Iraq in 2003. I know the House will understand the very clear reasons for this is with any, for that matter, client-legal relationship. It's to enable government to seek legal advice in private, I beg your pardon, without fear of adverse inferences being drawn from the content of the advice, or indeed from the fact that it's sought in the first place. It means the government isn't discouraged from seeking advice in certain cases, or pressured to seek advice in appropriate cases, and it protects that relationship, as with any client-lawyer relationship. The third point, Mr. Dowd, if I may, just to spend a few moments in talking about, and I'm conscious I will leave some time for the Honourable Member to come back, is just around Chilcot. There has been a number of changes after Chilcot, which of course was a major operation dealing out of the 2003 invasion. Operation Desert Fox outside the scope of the Chilcot terms of reference, but it does cover the use of military force by the UK in the US in Iraq in 1998, and it includes documentary evidence and witness testimony. So there is some that can be dealt with in there, and I won't, if you'll forgive me, go into the details of what is discovered in terms of the merits in that point. But there have been a number of changes which have changed since. There's a Chilcot checklist to support decision-making, the establishment of the National Security Council, which helps with the decision-making process. Law officers have to be consulted in good time. And so there have been a number of ways in which the situation has changed since the time he talked about. The Honourable Member for Tiverton asked me about the Cabinet Manual. There's been a convention developed that before troops are committed, the Commons is given the opportunity to debate the matter, which government has acknowledged in the past. And so whilst the general convention remains as is, there have been some amendment of points since then. I apologise, Mr Dowd. I hope the House is, for running over slightly. I do want to leave the Honourable Gentleman time to come back. I hope I've dealt with the questions he wanted. He can, of course, come back to me if not. 30 seconds, if you wish.
Thank you, Mr Dowd. I'd like to thank you for your studious chairmanship of this assiduous chairmanship of the debate. And I'd like to thank all of the members for their contributions. They've been very reflective and quite helpful. I particularly want to pick up on a few points that members made. First of all, Honourable Member for Strangford, for his sincerity and his passion, and also for his comments around the bravery of service personnel, which was something that I
Order. Thank you.